right. Think we got it. There we go. All right. So, good evening, everyone. I am Jen Spencer, and I'm in business development in DFW here at WRMC, formerly Worth Ross Management Company. I am so excited to welcome you all to our June Speaker Series event. If this is your first time joining us, we are so glad to have you. Welcome. These exclusive events are designed to bring industry-leading experts to the forefront, offering valuable insights, best practices, and an opportunity for you to ask questions. Our speakers are carefully selected for their understanding of the unique challenges and opportunities association boards and managers face. But before we dive in, I want to mention that we are recording the session. As I said, it will be available to all of our board members along with other webinars in the series. Our goal is to ensure every board member has the resources they need to lead their communities effectively. That brings us to tonight's event, the 89th Texas Legislative Session Update. So joining me tonight is Miss Leah Burton, member of Steptoe and Johnson, PLLC. Leah, how are you doing tonight?
I'm excellent. Thanks, Jen. Thanks for having me.
Absolutely. We are thrilled to have you. So just a reminder that the format will be similar to our previous events. Leah will present and we'll leave about 10 to 15 minutes at the end for Q&A. So if you have any questions during the presentation, just feel free to send them to me via chat and I'll make sure they're addressed during the Q&A portion. With that, Leah, I will turn it over to you to get us started.
Okay, thanks again, Jen, and thank you everyone for joining tonight's presentation. I'm going to go through what has happened during the legislative session. What I'm going to focus on primarily are the bills that passed and that are going to be effective come September 1 of this year. And then I also want to touch on some bills that were filed, didn't get passed, but we may end up seeing again next session. It's usually the bills that get filed are a good indicator of what people are thinking. Lobbyists are kind of discussing with their constituents, and so they give a good idea for us of what's going to come next session. So with that, let's get started. So again, I'm Leah Burton. I am a partner with Steptoe and Johnson. We have offices in Dallas, San Antonio, and in Houston, the Woodlands, as well as Colorado, Oklahoma, and all up and down the East Coast of the country. So I am one of the team leaders for our HOA department. So that is what I do exclusively is HOA law. I'm board certified in HOA law, and I'm also a fellow of the College of Community Association Attorneys. With that, let's dive into the legislative session. So this session, we saw 11,500 bills filed, which is pretty much average for what we see every legislative session. This might be a little bit higher than what we saw last session. Of those bills that were filed, 3,506 of them passed both the House and the Senate. Now, the veto deadline for the governor was June 22nd, so just a couple of days ago. And what that means is that if a bill passed, but the governor did not veto it come June 22nd, that those bills become law. So there are a couple of bills that did pass that were not vetoed that now are going to become law that affect HOAs. And again, the effective date of these bills is going to be September 1 of 2025. But like we always like to say, there's no reason to wait to the last minute to take action on the action items that we are recommending as a result of the passage of some of these bills. So with that, we have our first bill, which was a kind of a big one, and it was Senate Bill 711, and it was a fix, excuse me, from the 87th legislative session. So back in 2021, there was what we called HOA reform, where there was that big bill that passed that then said that religious displays could be pretty much anywhere on an owner's property, that homeowners could install security measures fencing, that the ACC could no longer serve on the board. Like, it was a big bill. And so last session in 2023, the lobbyists all got together, those who were part of the Community Association Institute, HOA World, the realtors, everyone gathered together and worked together to get a bill that would have fixed that bill. It passed through the House and the Senate. It was fantastic. Everyone was very excited. And then it got vetoed by the governor at the last minute because of an issue unrelated completely to HOAs. It was a property tax dispute the governor was having with others that don't involve us. And as a result, he vetoed our bill. So it was a priority item for all of us in the HOA world to get that bill put back on the agenda and to get it passed through with flying colors, which it was. So what does that bill, what does it now do? The first thing that it does is it, for all of you board members out there who are with condos on condo boards, what it does is it now makes condo management certificates a requirement. So if you are a condo that has at least 60 units or you are professionally managed by a management company, you now have to have a website that has all of your governing documents on it, accessible to your membership. You have to file that management certificate with the Texas Realtor Real Estate Commission within 7 days of the creation and recording of that document. You are now capped at $375 for your resale certificate fees. And as part of that management certificate, you have to detail your declaration, any amendments to your declaration. You have to give your owners the website address where they can go to look at the governing documents for the HOA. And then you also have to outline any fees that you as an HOA charge when property changes hands, like a transfer fee, a capital contribution, a resale certificate fee. All of that now has to be on the management certificate. So this, what the action item is on this one is that you've got to make sure you get those management certificates uploaded, first done, recorded in the county records where your property lies, and then you got to get them uploaded to the realtor's website. And if you don't have a website of your own and you have a condo of either 60 units or more, or you are professionally managed, you will need to get that website up and running before September 1, 2025. The next thing that this bill did, SB 711, is it fixed the security measures fencing statute. So what the statute originally said, the one that we didn't like back in 2021, was that basically a homeowner could come to you and they could say, we want to build a fence around our perimeter and there's nothing you can do to stop us. And this does apply to single family and condos, but if you're in a high-rise condo and you're scratching your head right now, it's not going to apply to you. It's going to apply to more of a land condo, like a condo that has basically like a detached single family home that has its own yard and can actually accommodate a fence, not to a high-rise condo. So this fix to that bill, what it now does is it says that a homeowner, yes, you can install a perimeter fence, but it says that an HOA can restrict the placement of that fence on if it goes over a sidewalk or a drainage area or an easement. And so you can't just put your fence any which way you want to place it. It also has it so that you have to put a driveway gate, if you have one, at least 10 feet from the street. So you can't be putting that perimeter fence in the street so that vehicles can't get in and out of your alleyways. The one thing that it does is it protects homeowners who have a front yard fence up to September 1 of this year. So if someone has installed that front yard fence, they're good, they get to keep it. But anything after September 1, you can now dictate that people cannot have a front yard fence. And that was one of the big concerns with this statute when it came out in 2021, was that communities that you drive through and the aesthetic is, oh, well, there are no fences in the front yard. That's what we like. That's the kind of community we're in, that people there was going to be like a one-off yard that had a front yard fence and then the next yard wouldn't, and it would just look choppy and aesthetically displeasing. So this statute is now attempting to fix that by allowing HOAs. And you see on here it says POAs. When it says POA, that means HOA. That means community association. I'm using that term interchangeably. But now HOAs, POAs, will have the ability to say, no, you cannot have that front yard fence. The other thing that this statute does is it is going to allow an HOA to take into consideration if there is a hazard or a risk to health or safety when evaluating a homeowner's plan for a security measures fence. So they can't outright deny it, but they can review and consider those elements and possibly make conditions in accordance with those risks of health or safety that the board has identified. So the action item on this one is if you have a security measures fence policy, which most communities do after the 2021 legislative session, you now will want to go in there and amend that policy to incorporate what the new law says. Once again, that is September 1 of 2025 for an effective date. So there's time to get things underway and to get yourself all lined up and situated before that effective date. And then finally, what SB 711 does is, and just to go back to 2021 for a second, the 2021 legislative session, the bill that came out said that HOA members can no longer serve on an ACC. So if you are around in this world back then, maybe serving on your board or somehow involved in the HOA industry, you would know that HOAs really had a hard time, scrambled, because nobody wants to serve, let alone it's a struggle to find people to serve on the board, and then to try to find people to serve on an ACC who are unrelated to board members was just really, really difficult. And so what this statute now will do is HOAs will have to send out that same candidacy form that they send out when they're trying to get people to submit for board candidacy. You will now do that for the ACC as well. And once you go through that motion, if you don't get any takers, if you don't get any candidates, then the board or those who are affiliated with the board, a spouse or someone living in the board member's home, can now once again serve on the ACC. So it's going to help that problem that was created back in 2021. Of course, there still are those conflict of interest issues that come into play if you have, for instance, a board member serving and then you have their spouse serving on the ACC. There's that potential, the appearance, of impartiality that comes into play. But at least now, if all else fails and you can't find someone to serve on the ACC, a board member can now serve in that dual role. Action item for this bill is to, if you adopted a hearing policy after the session a couple of months ago or a couple of years ago, you will want to update that policy to show that once the board and the HOA have sent out the candidacy form, if they don't get anyone who wants to serve on the ACC, that board members can now serve on the ACC once again. So that will also require an update to that policy. Okay. Next. So this bill also came up last session, and then from what I remember, I think they just ran out of time, or it didn't get on the final calendar, and they just ran out of time. And so this one was one that no one really had an issue with. There weren't any opposition to it. You'll recall from back in a couple years ago during COVID when virtual meetings became the thing, and we all learned about Zoom. We all became like pros with Teams and Zoom, and virtual meetings just became the way that we did business. And so HOAs also took advantage and would have their meetings virtually. But there was no statute in either the Condo Act or the Property Code for HOAs, Chapter 82 or 209, that actually allowed for those virtual meetings. Now, we were able to rely on the Nonprofit Corporation Act, which does talk about virtual meetings and electronic voting, but it wasn't actually in 209-82. And so what this bill does is it basically now says that an HOA, either a condo or a 209 single family community, can have virtual meetings, can vote electronically, and what your bylaws will usually say is that you must allow homeowners to vote either in person or by proxy, and the statute has now been changed to add and electronic balloting as one of those voting forms that homeowners are allowed to vote on by. So this was a great kind of dive into the future. It needed to happen, and so this one, we're really happy that this got to the finish line and ended up passing. So what you'll want to do for this one is make sure that you've looked at your bylaws and you know that you have provisions in there regarding electronic voting, virtual meetings, and that there isn't something in there that says you're not allowed to vote by electronic ballots, because that is now the law as of September 1, 2025. And next, we have what I call the Leave Dead Grass Alone bill. It's also been called the dead grass or brown grass, let brown grass live, whatever. But basically what it says is that if there is a period of water restriction that has been dictated by a government, a utility, a municipality, that you as an HOA or POA, you can't fine an owner for having dead grass or turf during the period of that water restriction. And then you also cannot fine them up until 60 days after that water restriction is lifted. So cannot fine for dead grass, dead turf during period of water restriction. And this one was met with, I've given this presentation before, and there have been some homeowners who have questioned and not understood what is meant by water restriction, what is meant by residential water restriction. And I will tell you what the statute says is a residential water restriction dictated by a utility or municipality or the government, and it does not go into further detail. So the way that we're interpreting it is basically during the middle of the summer, when you get your email or your text from your city, your county, your municipality that says, we are now under water restriction, you're only allowed to water on this day and this day, that's the period of time that we're talking about. So during that period of time, you cannot fine an owner for having dead grass or try to get them to install trees or turf. Now, a question has come up before. Well, does this mean that we cannot require them or issue violations if they have weeds? That's not what this says. If you've got a lawn that looks insane, that's got a bunch of weeds growing, it looks crazy, just because there's a water restriction in place doesn't mean someone can't get out a lawnmower and mow down the grass. It's just if it's dead, you can't force them to install grass that is just going to die in a couple of months due to the water or the fact that we're in a drought at the time. So action item on this one, review and update your fine and enforcement policy. If you have a category in your fine policy that says landscaping or dead grass, $500 fine a day, you're going to want to put a little asterisk on that fine policy that says, unless during a period of water restriction per section 202008 of the property code. Now, I believe this is the last one that passed, and then I'm going to get into the ones that did not pass, just so you can have a laugh during this evening before you go on with your night. So what this bill, HB 621, what it did and does is it amends 202 of the property code, which applies to both condos and single family communities. And what it says is that you cannot restrict people from coming to your common areas on a political basis, inviting government officials, inviting candidates who are on a ballot or who are just there to meet with the membership. You cannot say that cannot happen. And there are a lot of communities out there that do have policies that say, you are not allowed to use our clubhouse for political reasons. And the reason before that is there's always been a fear that if you allow in one political group, then like the opposing political group is going to show up guns blazing and there's going to be like a shootout outside the clubhouse. And HOAs typically just try to stay out of it. They want to stay out of politics. You want to stay out of religion. They want to stay out of all those things. And so a lot of HOAs have adopted policies that say, you can't use our clubhouse for any kind of political activity. What this bill and statute now says is, yes, they can. They can come, they can use your clubhouse for political gatherings, to meet the candidate night, whatever they want to do, and they can invite people from outside of the community to participate in those meetings. Now, what the caveats are is that this does not apply to a common area that is just used for membership meetings or board meetings. So if you have just like a conference room and that room is exclusively used for meetings, that's not the kind of space that this bill is talking about. This is talking about like a common area, a pavilion, a clubhouse, a green area out on the lawn. It's talking about that type of common area. So what the HOA can do, so they're not powerless to just stop any kind of activity. They don't have to just open the gates and just let everyone come in. What they can do is place restrictions on the hours, and still impose a registration program or requirement. They can have rental fees, just like they would do for any other type of club or meeting that wants to use the common area. So even like a party, just a rental for any kind of thing. So you can require a security deposit, make sure that no damage is done, and you can also set the max occupancy for the room depending on what the max occupancy is for that room. So the HOA does have some authority to dictate the use of the room. They just cannot dictate the content that is being delivered inside that room. So for this statute, the action item is that you want to look at your common area reservation, rental policies, any rules and regulations you have with regard to those items, and just make sure that you don't have in there no political gatherings allowed in the clubhouse. And so that's something that you will want to do. And if you have a policy that says, again, no politics in the clubhouse, that will have to be repealed, or it will have to be overturned. So one item I just want to mention that doesn't apply to a whole lot of HOAs, but if you were a 501c3 HOA, and the way that you'll know this is if you've been told that you didn't have to comply with the Corporate Transparency Act, you're a 501c3, you don't have to comply with this statute. So that means that you can prohibit anybody from using your common areas depending on whatever you want to do. So you are not bound and subject to this statute if you are a 501c3 community. Oh, there is one more bill that passed. All right, so this is the solar roof tile bill. This one is not very, there's nothing sexy about this bill. This was House Bill 431, which all it does is it adds solar roof tile to the definition of a solar energy device. So most, if not all, HOAs on this call should have a social or a solar energy device policy of some kind. What you're going to need to do now is make sure that you update that policy to include solar roof tiles as a form of solar energy device. Now, this is not to be confused with energy efficient shingles, which are already protected. That's different. Energy efficient roof shingles are different from solar roof tiles. And I don't live in that world, but there is a distinction there. I'm sure if you know what the rules are, or you know about solar, you know the difference. But all you need to know for purposes of this bill is that solar roof tiles are now considered a solar energy device. All right, so let's move into the bills that failed. But anyway, before we move on to the bills that failed, let me just say this was a relatively, I don't want to say easy session, but the bills that ended up passing, none of them cause us much heartburn in the HOA world. They're going to require a little bit of, review and updating, but there's nothing in here that is causing us great concern like it did back in 2021. So this was a pretty solid legislative session. But I'm going to show you a couple bills that, had they passed, we would have been in for a world of hurt. First of them being this session's chicken bill. There were, I think, 3 chicken bills this go round, and there's always at least one. And it's every single session there's a chicken bill. This chicken bill, the first one, was going to allow individuals on lots to have 6 chickens, 6 rabbits. You could have cottage food production, and all the HOA could really do was make sure that people were controlling odor and safety and sanitation, and they could limit the total number of chickens. They could prohibit roosters. They could have established a minimum distance between the coop and the house next door and the fence. They could have limited the area on the yard where the coop could have been located. But essentially, people, even if you were on a 0.2 acre lot, you could have had chicken coops and 6 chickens and rabbits, and you could have a garden in your front yard, and there's nothing the HOA could have done to stop it, apart from these certain little requirements and restrictions that they could have put on it. So we did not like that one, we in the HOA industry, just because we know that in a community of 0.2 acre lots all lined up together, a bunch of chickens. You can imagine with the predators that show up. We already have bobcats running all over the place in DFW. And to have then, potential for bird flu, just lots of issues. And so this was opposed quite aggressively, as well as this one, which was HB 2013, which was a bill that would have restricted HOAs from telling homeowners that they couldn't keep chickens. Even if the municipality or any ordinances allowed chickens, then homeowners associations could not stop chickens from being on lots. And it applied regardless of the size of the lot. So it would have applied to single family and townhomes. Even if the lot was, tiny, people could still have had chickens. So again, this one was met with a lot of opposition. Committee hearings, people spoke out, and it ultimately did not pass. But I can guarantee you that next legislative session, there will be at least one chicken bill. Next, this was a very hotly litigated, hotly advocated bill on clotheslines. And for what reason, I don't know, but apparently the clothesline issue is a big one in certain communities. And what this bill would have done would have said that HOAs cannot stop people from hanging clotheslines to dry their clothes, as long as the clothesline wasn't visible from the street or from an adjoining street. And again, I don't really know the history on this, why this was such a big deal, but a lot of lobbying time and money was spent on this clothesline bill. So it didn't pass. And this one really just kind of like ran out of time. It wasn't hotly opposed. It ran out of time. But again, not something that would have changed the landscape of the HOA world. So not quite sure what the history was on this again, but yes, it did not pass. The next one that did not pass, thankfully, was this bill that would have added a section to 209 of the property code that would have required HOAs to file their rules and regulations with the Texas Real Estate Commission within 7 days of filing the management certificate. That would have been just a humongous burden on HOAs that struggle just to get the management certificate filed in time. But now to have to file your rules and regulations, and what if you don't have rules and regulations? It just would have been a huge administrative burden. And so that did not pass, thankfully. The next one that didn't pass, and phew, we dodged a bullet on this one as well. This would have amended 209 of the property code to allow people to submit their books and records requests by email, mail, regular mail, hand delivery. So it would have eliminated that certified mail requirement where we always fall back when we have a homeowner that just will not stop and they email and email and email and I demand these documents, I demand these documents. And we say, well, no, you have to submit a certified request before the HOA is obligated to produce those records. We wouldn't have been able to do that anymore. We would have had to allow a homeowner who, is in the middle of the night sending records requests. We would have had to honor that request and then respond and provide responsive documents within 10 business days of that request. So luckily this one did not pass. It died very early on, and again, very, very luckily. This statute, or HB 5011, what it would have done would have amended 209, so doesn't apply to condos, only would have applied to single family communities, but it would have allowed an owner, if they were in the midst of a lawsuit against the HOA, to withhold their assessment payments while the action was pending. And if the HOA won, the owner had to start making their assessment payments again. But if the owner won, then the HOA couldn't sue to collect assessments, which this one was just so bad and so scary, especially because homeowners now can go out and just file a lawsuit in a JP court with the justice of the peace, and that would have triggered them to not have to pay their assessments. So this one also did not go very far, very, very luckily. HB 5225. This targeted fining and fencing, and really what it tried to do was rein in an HOA's authority to regulate certain things. So the first thing that it wanted to do was place a restriction on HOAs so that they could not impose unreasonable fines. Unreasonable fines have not been defined by statute, so we don't have that kind of authority from the courts yet on what is an unreasonable fine. But HOAs would not have, they would have been restricted on the fining front. And also the HOA could not have increased assessments from one year to the next over an unreasonable amount. Again, what is unreasonable? It was not defined, but could increase the assessments over an unreasonable amount if the majority of the homeowners approved. So again, this would have been unworkable really. And then the other thing that this bill was trying to do was tell an HOA that it could not stop a homeowner from making minor improvements without getting ACC or architectural approval. So like an HOA would not be able to stop a homeowner from like repainting or putting up their perimeter fence or improving their landscaping. They would have been able to do those things without seeking and obtaining approval. So that's a little scary. And then finally, it added in this one section where an owner would be required to obtain the HOA's approval to have short-term rentals. And so that, again, it was a big old bill, but it did not pass. This bill was also included some talk about fines, but it was changing the definition of when declarant control ends and the homeowners take over the community. It also was saying that a board meeting had to be held within 10 miles of the subdivision if the HOA was still under declarant control. It also had placed a restriction on the amount of fines that could be levied by an HOA. They had to be reasonable. And also the HOA would have had to establish a maximum fine amount. So if a person had a continuing violation, like the trash can never leaves the front yard and they get fine after fine after fine, this bill would have required at some point that those fining amounts to be capped for a violation that was just continuing on and on and on. And then finally, it would have stated that an HOA could not increase their assessments more than 5% per year unless a majority of the lots approved, which HOA documents have their own restrictions on the increase amount of assessments, and that's how declarations and covenants are structured. This statute would have tried to take that authority away from the HOA and make it a statutory requirement. And so this bill did not go very far and also would have been very difficult to enforce. So we dodged another bullet on that one. This one, and there's always something that comes up about flags and signs. And the reason why this one came about was because there has been a lot of talk in HOAs about political flags. Now, we know that political signs are protected, political signs, but it has to be a sign that has something to do with a ballot measure that's coming up in an upcoming election or a candidate for office. And what people were doing was putting kind of like political messaging out on their signs and political flags. And so there was what constitutes a political flag, what constitutes a political sign, and vice versa. And so what this bill wanted to do was say that an owner could display a flag, a political flag, just like they could do for a sign. So you could have that political flag up 90 days before the election and then take it down within 10 days of the end of the election. And so it basically was just taking what is already in the election code for signs and using it for flags, for political flags. And this one did not pass, but it will probably be back, I would think, probably next session. And then this one talked about political signs. And so it would have added a section to the election code, which would have prohibited an HOA from restricting people from putting a sign in their yard that contained a political message. So there have been a lot of signs, flags out there that are talking somewhat about politics that HOAs will say, you have to take that sign down because even though it contains a political message, it's not advertising for a candidate or a ballot measure on an upcoming election. And so it doesn't qualify, you have to take it down. And so what this bill was going to do was say, hey, if the sign has a political message, it's allowed to be up. And this bill did not pass. This bill, HB 5438, was going to add a section to 202 of the property code, which applies to both single family and condos. And it would have removed the HOA's ability to enforce limits on leasing for terms of over 6 months. And it also would have not allowed an HOA to impose occupancy limits on those that are in section 92 of the property code, which says that the max number of adults in a home is 3 times the number of bedrooms. So you got 3 bedrooms, you can have 6 adults. And so this bill, honestly, I thought would have gone further, and it didn't. And I think it's just because the lobbyists had to focus in on the ones that they really wanted to get passed, and this bill just did not get there. And so it died, and will likely, some version of this bill will likely be back next session. This bill, and we are getting to the end. Let me check on the time. Okay, we're good. We'll have plenty of time for questions. HB 509, what this bill would have allowed is people to come and canvass in your community for political messaging. Like if you had people who wanted to come to the community and get people to register to vote or to sign political petitions, and you have a strict no solicitation rule in the community, you have your sign outside that says no solicitation, you would have had to allow people to come into the community and canvass your neighborhood. And it would have been an amendment to the election code. And the only thing that the HOA would have been able to do is basically put restrictions on the time, like 10 to 6, Monday through Friday, has to be, during, yes, again, like Monday through Friday, can't do it on the weekends. And so they would have been able to place just those little restrictions on it, but they would have not been able to flat out prohibit people from coming in and canvassing the neighborhood. And so this one also did not pass, but probably will come back. And then this might be our last one. This one, so as you likely know, in your bylaws, you have a provision in there that talks about vacancies. If you have a vacancy on your board by reason of death, resignation, removal of a director or an officer, that the majority of the remaining board members can appoint the replacement for that person who vacated the position, and that person will serve out the unexpired term of their predecessor. What this bill would have done is require an HOA, anytime there was a vacancy on the board, to have a special election to fill that vacancy, which just the financial consequences of this bill, had it passed, would have been just so burdensome on an HOA that it did not draw a distinction between if the vacancy happened 2 days after an election or halfway through a 3-year term. So ideally, someone could have been elected and decided the next week, well, I've had second thoughts. I don't want to do this. I don't know what I was thinking. And then they quit. And then the HOA would have had to spend all that money to send out election materials to have a special election to fill that vacancy. And so this was not a good one, and luckily it did not pass. And so I know I've said we've dodged a bullet a couple times during this presentation, but we dodged a bullet on that one. And then, gosh, I thought we were at the end, but here we have just a couple more. So this one, I'm calling the swim class bill, HB 1133. And this bill statute would have said that you could not tell a homeowner that they could not host swim lessons on their property. And the HOA could have restricted the location, like if your pool was on the side of your house and there was just like a wrought iron fence, you could have said, no, you can't. If people can see it going on, then you're not allowed to do it. But if it's in your enclosed fence in your backyard, no one can tell that it's even going on, then you as a homeowner would be allowed to do that. Also, it would have allowed the HOA to say you can't have more than 4 students at a time. You have to make sure you have a permanent restroom. And the restroom thing came about because there are and have been people in the past who were they were hosting swim lessons on their properties, and then their students would leave the property and they'd go out on the front lawn and they would just drop their swim clothes and just pee on the front yard or the neighbor's front yard. And so neighbors were like, what is this? This is not okay. We can't just have kids peeing all over the front yard. And so they said in this bill, statute would have required that there be a permanent restroom for students to use so that these kids weren't out, in the driveway peeing on the yard in full view of everybody. So that did not pass, but it probably will come back at some point. And then finally, I promise we are at the end. HB 2398 would have amended section 209 of the property code. And what it was trying to do was make a requirement that a dedicatory instrument or a governing document of the HOA, that it could be amended either by a majority or a higher percentage if your instrument required it. So if you have bylaws that say these bylaws can only be amended by a vote of 90% of the membership, then by golly, 90% is where you're at. If it didn't say that, then it would be a majority in accordance with this statute. It also scarily was trying to add a section to say that board members are liable as fiduciaries of the owners, which would have basically expanded or increased the liability of a board member or the exposure of a board member to personal liability for acts that they take while on the board. And so that was a little bit scary. And luckily, this one did not pass. And so the good news is all these horrible ones I just told you about, they didn't pass. And the ones that did pass, we don't have any problem with. And so that is all I've got for you tonight. And I am now ready to answer any questions that anyone may have about these bills. So let me hear it.
Yeah, so we've got 2 different chats going. Sorry, guys.
Oh, okay.
That's okay. I've got it under control.
Okay.
Okay. The first question that we have is from Tim Ramsey.
Okay.
And he asked, does the website with governing documents have to be available to non-owners? For example, prospective buyers, tenants, and so on?
No.
No. Okay.
You can still have it behind, it can be password protected. It just has to be able to be accessible to your homeowners.
Awesome. All right. John Ellis says, is there an equal time requirement?
Equal time requirement.
Equal time requirement. John, are you there? Can I unmute you? All right, John, if you think of it, help us and we'll come back to your question.
Said that was about political meetings.
Political meetings.
Political meetings. Is there a time limit, like on
an equal time?
Oh, so like if someone was going to have a meet and greet for a candidate for a certain political affiliation, would equal time be allotted for like the opposing? So it didn't delve into that, but like if you were to find out that like a Republican group was going to host a meet and greet, then certainly a Democratic group could also, I don't think join the same meeting, but they could also reserve the room and do like a similar meet and greet on their own time. I don't think that you could have like a full-on debate. You wouldn't be required as an HOA to allow a full-on debate to happen at the same time, but everybody from every political affiliation would have equal opportunity to reserve the room to use for their political gatherings.
Gordon writes, what is the status of short-term rentals and condos? I'm in a high-rise in Austin, and we constantly struggle with random owners or even renters using units for STR, prohibited in our regulations.
Yeah, this I could talk for hours on this and do often talk for hours on this in other, like not here tonight. We don't have the time, but it is a huge problem and it's only getting worse. And the only way to rein it in is to get the membership on board to amend your declaration to restrict it. And there are a lot of communities that I had like 100% track record on getting these amendments passed. And then I was confronted with a community here in DFW that um, they didn't realize that half of the community was already rented. And so when it came time to get votes for the leasing amendment, they found out by going door to door, there were a lot of rentals that they didn't even know about, and they all rallied together to stop that amendment. So my best advice is get to it quickly before it gets out of control, and rally the homeowners together and get an amendment passed so that you can restrict and put like a cap on the number of leased properties and restrict investors from buying. Make it a requirement that homeowners have to live in the unit I have a community that said you have to live in the unit for 24 months before you're allowed to rent it. I mean, there are things that you can do to rein it in, but you need to have the community support to do it.
John Ellis also writes, if the management company has a portal for owners, does that count as a COA website, or are
Yes.
we required? Okay. Or
That
are we
counts.
required to have one? Okay.
Yep, that counts.
Great. Steve from 360 says, in regards to SB 2629, is virtual access to in-person condo association meetings optional or now mandatory?
Optional.
Okay. Smokey says, does this still include parks and pool areas? Smokey.
I wonder if he's talking about the political gatherings. It talks about common areas. It's not distinguishing between like a pool area, but certainly if you have an area that is for the pool and that's the designated use of that area, that's not something that you would it would be forced to allow a political gathering in the pool area or the fitness center. There have to be like an actual room, some kind of facility that you would have to have on site in order to accommodate that kind of gathering.
Bree Balderman says, can we get your law firm to give us a package deal to get all these resolutions typed up and sent to our boards for a good deal?
Maybe. We are talking about like because usually most law firms put together some kind of like a package deal depending on what comes out of the legislative session. So maybe, yes. Stay tuned.
Stay tuned. Smokey again asks, can a member previously denied be the second or third in the ACC committee?
Repeat that one again.
Can a member who's previously denied be the second or third in the ACC committee?
Who's been previously denied, like to serve on the ACC or to serve on the board? I mean, there's no requirement on the part of the board. So usually ACCs serve at the pleasure of the board. The board has the authority to appoint and remove them at will. And so if someone has submitted for an ACC position and been denied before, there's no obligation on the part of the board based on this statute to now place that person on the ACC just because of this statute. The board still maintains that authority. If that's the question that was being asked.
If it is, yes. I'll get clarification.
Okay.
And then the final question that I have is again from Bree. It says, will the owners who have already built these fences have to remove them, or are they grandfathered in?
If they have been in place when they're grandfathered in until September 1, 2025. If they try to build after that, then no.
Okay. A couple more questions just came in. Pat Trapp says, does the $375 cap under SB 7Q1 apply to AGH and TH or just condos? AGH. Townhomes or just condos?
It applies, well, it applies across the board now because it applied to single family and townhomes from a couple sessions ago, and now it's been extended to condos. So now it's going to apply to everybody.
Jolie Wallace asks, is a rental cap of 30% a good cap, or what would you recommend?
I know Jolie.
Hi, Jolie.
Hi, Jolie. It depends on the community, and honestly, I've seen communities go as low as 5%, and I've seen them go as high as 30. But it kind of depends on the size of the community. So if you have a community, you have to discuss it with the attorney. But if you have a community that has like a large number of homes in it, and you want to really tackle it, I would go lower. And this is where a survey comes in helpful, because sometimes we will have and this is something that I really advise my HOAs to do, is send out a survey ahead of time and say, if we were to put a 30% cap, would you vote yes? If we were to put a 20% cap, would you vote yes? And then get that feedback from the community, because you want the thing to pass. So if you set the percentage too high or too low, and that's why it fails, well, maybe you could tackle that on before you spend all the money to send out the voting materials and everything, and find out then. So I think the answer to your question, Julie, is it depends. That's the lawyer answer. But also I think 30% is kind of high. I'd go lower.
I think that is all the questions from both of our chats. We have a few minutes left. Does anybody else have any pressing questions for Leah before we give your time back? Got one from Lynn.
Okay.
Our declaration calls out that the board can make other rental rules. We have a 10% cap on rentals. Is that safe, or do we need to amend the declaration?
So where's my little disclaimer? There's my last slide has my disclaimer. So just, I'm gonna put that out here. I don't know if I'm not your lawyer, this webinar does not create an attorney-client relationship between us. So take everything that I'm saying with you, to you, and make sure that you cross-reference it with your attorney. But I will say that if you have the authority to lease, if your declaration gives you the authority to set restrictions on leasing, you may be able to get away with certain things. Like you could require someone to pay a registration fee when they lease, or give you a copy of the executed lease 14 days after its execution. I would tell you also that based on the case law at present, if you don't have regulation of leasing authority already in that declaration, then trying to institute a cap or a minimum residential requirement on by policy or by rule and regulation, I would fully expect would get you into a courtroom, because the case law has been pretty strict that it's got to be in that declaration, and it's been hotly litigated, a couple times over. So I would err on the side of go for a declaration amendment. But of course, I would have to review your declaration in order to give you a concrete opinion on that front.
Great. And one more just came through. Mr. Paul Putman, he asks, are electronic ballots required or merely allowed?
Allowed.
Merely allowed.
Yep.
All right. I think that's all of our questions.
Okay. All right. Well, now everyone can go. You can go out to dinner and tell everyone about all the new HOA laws.
Sounds like a great Friday night, Thursday night, Monday night, whatever. Thanks again, Leah, for being with us and sharing your infinite wisdom and knowledge. We feel super privileged. Thanks to all of our participants, any of our first timers. Yes, we will, Gordon, yes, we will circulate this presentation. Again, the video will be posted on our YouTube channel. And if anybody has any other questions, you can direct them towards me. And I hope everybody has a fantastic Thursday night.
Thank you. See you,
Bye, y'all.
everyone. Bye.